Welcome to Employment Law This Week. I'm George Whipple. Our top story, former employees turned competitors in Pennsylvania hit with $4.5 million in punitive damages. An insurance brokerage sued a group of employees claiming they violated their non-solicitation agreements by luring employees and clients to launch a new office for a competitor. A lower court awarded the firm nearly $2.4 million in compensatory damages and also awarded $4.5 million in punitive damages because of the defendant's outrageous conduct. On appeal, the appellate court agreed and upheld all damages. Anthony Laura has more.
Punitive damages were awarded in this case for what I think were several reasons. Initially, the court did sustain tort claims against these defendants, which supports an award of punitive damages. Secondly, the defendants' conduct in this case was particularly egregious. They willfully took information from their former employer. That was the plan that they had all along, and in fact, their first year of business was derived solely from the clients of their former employer. And lastly, I think the court was annoyed with these particular defendants for having ignored his discovery rulings and orders in the case, and in fact having violated a preliminary injunction order that the court put in place. That's certainly a recipe for punitive damages.
Executive pay is subject to clawback regardless of fault, the Ninth Circuit says. The SEC recently sued a former CEO and CFO seeking to take back compensation under Section 304 of the Sarbanes-Oxley Act. The action came after the company restated its financial results due to accounting improprieties. The executives argued that they personally did not engage in misconduct, so their pay should not be subject to the clawback. The Ninth Circuit disagreed, finding that Section 304 applies whenever companies restate results due to misconduct. While we've seen similar rulings from lower courts, this is the first time a federal circuit court has taken this view. The EEOC voices its support for the NLRB's new joint employer standard. In an amicus brief filed with the D.C. Circuit, the Equal Employment Opportunity Commission backed the NLRB's new joint employer test, which eliminates the requirement that a joint employer exercise direct and immediate control over employees. In the brief, the EEOC argues that its own joint employer standard is consistent with the NLRB's and that the flexible nature of the test is necessary in our current economic climate. OSHA's new walk-around representative standard is facing legal challenge. The National Federation of Independent Businesses filed a suit against OSHA over its new standards for walk-around rights during inspections. The agency recently released guidance stating that non-union employees could designate a union representative to accompany OSHA officers during a workplace inspection. In the past, this walk-around representative was generally limited to an employee of the workplace. The NFIB alleges that OSHA made this change to allow unions easier access to non-represented employees, but failed to comply with the procedural requirements for amending federal regulations. And that brings us to our tip of the week. Denise Davin, attorney and senior HR executive, is here with some advice on best practices in risk management.
Risk management helps to ensure the ongoing health of our organizations, as well as the success of new business ventures. It is key that we include the people aspect in our analyses of risk management, and not just focus alone on corporate legal matters, financial health, and reputation. Examine the talent management programs and processes of your organization. Undertake an analysis of whether you have talent in your key roles with the right skills and capabilities, a productive succession planning process, and an analysis of whether there are any recruitment, retention, or engagement initiatives that might impact your success.
Thanks, Denise. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.